This is going to take me a little while. I'm going to speak to the Nicopure and Right to Be Smoke-Free Coalition's court decision, which came down from Judge Amy Berman Jackson, United States District Court, District of Columbia. She is one tough judge. She's a tough girl. She is a tough girl. You got to respect her intelligence. I tell you, she's a highly intelligent person. And, you know, she even sort of said in the decision that her heart sort of went out, in a sense, to what could possibly happen to the industry in the long run. But she's going to be a judge, and that's all there is to it. She's going to look at it in a cold, deliberative, objective manner, and that's what she did, regardless of the long-term effects that may very well happen to the industry. Congress is just going to make it worse for us. In fact, even H.R. 2194, the Hunter legislation, chances of that going through Congress, it may very well be the doom of the vaping industry as we know it. And the only thing you wind up having is the heat not burn technology from Big Tobacco, or Altria / Philip Morris USA. But anyway, it's neither here nor there. When this goes on appeal, I'm going to forecast that her decision, for the most part, if not all of it, will be upheld. She wrote a very, very tight decision. I took down all the notes. I'll be speaking to them all. I don't know if you can see this. Some there. Some there. And some there. I have a lot of points to make. It took me about an hour or two to do this video. The lawyers for Nicopure Labs and Right to Be Smoke-Free Coalition made a lot of mistakes. They made a lot of mistakes. The industry or Nicopure Labs and Right to Be Smoke-Free Coalition may want to hire someone else. Certainly don't want to use those appellate court lawyers and those law firms for this appeal. That's my only advice to Nicopure Labs and Right to Be Smoke-Free Coalition. Of course, they do not read. I mean, they do not watch my channel, so. But nevertheless, yes, those lawyers made a slew of mistakes. Even the judge pointed them out many times in her decision. Certain areas that they did not raise, and some of their arguments that they did have were just not only unsubstantive, but were irrelevant to the subject matter of the Tobacco Control Act of 2009, as well as the FDA final rule. We have a serious problem here, guys. No one's probably going to help us out. I had thought that it would be a partial ruling with this court case, but of course that did not happen. She has given the FDA, HHS, CTP, unrestricted, full power, full authority with this decision. And by law, too. I mean, she gives a reason legally. You understand? She didn't just make it up like she's against us or anything. No. She, especially with the legal standard, she has spoke to many cases, so U.S. Supreme Court cases, And some of the stuff I've talked about on the FDA final rule already, but she goes into much more detail. So anyway, let me read this for you. So if this is United States District Court for the District of Columbia. As you can see, Nicopure Labs versus FDA, Y2B Smoke-Free Coalition versus the FDA, civil action number 16-0878. ABJ means Amy Berman Jackson. As for Nicopure Labs and civil action number 16-1210, ABJ, they had a consolidated motion for summary judgment, as well as the Y2B Smoke-Free Coalition had a unique separate individual motion for summary judgment as well. So we go down to page 3. Last line, first paragraph. And it states, in the deeming rule, the FDA simply announced that electronic cigarettes or electronic nicotine delivery systems would be subject to the same set of rules and regulations that Congress had already put in place for conventional cigarettes. I'm gonna make that a little bigger so they don't go off the page. Yeah, make it a little bigger, a little easier for you to see in case you're on a small screen. So, you know, ends, as I was talking about, delivery of nicotine, electronic cigarettes, all the same concept. Congress, of course, put that in place with the Tobacco Control Act of 2009. Go down to page 4, first paragraph, first line. The rule requires manufacturers to subject their products to review before marketing them, to tell the truth when making any claims about their health benefits, and to warn consumers about the dangers of nicotine when offering a means to deliver the substance to consumers. That's why all these manufacturer finished product dates after August 8, 2016 are illegal, because they have not been reviewed by the FDA. Page 4, last paragraph. In the first portion of the case, though plaintiffs claim that the FDA exceeded the authority given to it by Congress because certain types of devices or liquids do not fall within the statutory definition of tobacco product that may be deemed to be subject to the TCA or Tobacco Control Act, but that challenge is extremely narrow. The challenge to the FDA's authority is not about whether the FDA had the legal authority to regulate the cigarettes that comprise a large portion of the e-cigarette market. The plaintiffs in this case concede that the agency may regulate those products. And plaintiffs do not challenge whether the FDA had the legal authority to regulate closed vaping systems, which use e-liquid that comes in a disposable cartridge. Now, this word here is what got them in trouble. Gave way too much of a gap for the judge to, well, rule against them for one thing. And you have to understand something. The claims that are in this particular court case with Nicopure Labs' right to be smoke-free coalition, when they go up on appeal, they can't change their claims. They could change their argument, their legal argument. They could cite cases, different cases than they have already in this lower court, but they can't change the claims. And that's why her decision is going to stick, probably. I'm going to give it a 90% to 95% chance, not chance, but 90 to 95%, possibly even 100%, that a surety that her decision is going to be affirmed on appeal. I mean, that's how tight she writes her decisions. I spoke about this in the past already on the FDA final rule. She is extremely, extremely deliberative when it comes to these court rulings. Page 5, second paragraph, last line. The FDA has plainly stated that the rule does not cover e-liquids that do not contain or not derived from nicotine or tobacco unless those liquids are reasonably intended to be used with nicotine-containing liquids. See, that's the thing. I'll get into this later with the nicotine-free situation. But when you take nicotine, let's say a 0 milligrams of nicotine and you put it into your tank or whatever have you, or RDA or whatever, and you're vaping on that, well, it may get contaminated by other juices that you have in that particular RDA or tank that had nicotine. Also, it goes to the intended use. It goes to the unless those liquids are reasonably intended to be used with nicotine-containing liquids. Now, she gets into a little bit more in depth with this whole nicotine-free situation, and she makes her point very well. I mean, it sticks actually. But anyway, and the other thing is that's why it's not so much you have to go through a PMTA or substantial equivalence or exemption for substantial equivalence pathways for zero nicotine, but you do need to be registered with the FDA to prove to the FDA that there is absolutely no nicotine inside of the zero nicotine e-liquid. We have to show that. So that's costly, less of a process, but you still have to prove that to the FDA. That's up. So that's third. The court concludes that the agency acted within the scope of its statutory authority. It was legally permitted to regulate that category of liquids and to consider a refillable electronic nicotine delivery system to be a component of a tobacco product and therefore subject to regulation. I explained this in the Tommy Vapors Make a Right series. I think it was 147 or 146. As time goes by, it gets more in depth. I hate this Logitech C920. I have to really work on this color. The color is still screwed up. Look at that. With the C5, what was it, 525? I adjusted it and it was okay. Like if I sit away from the camera, I'm fine. But if I come close, it's all yellow. It's kind of weird. Anyway, so let's go to page 6, second paragraph. The vape here. I said it'd be a 100-page decision, and it was 93 pages. I was quite close to that. It says, it bears repeating that the provisions the plaintiffs find most objectionable were not crafted by the FDA as part of the deeming rule. Instead, they are requirements of the Tobacco Control Act that was enacted by Congress. Congress gave the FDA broad authority to deem new products to be tobacco products, subject to that existing statutory regime. And the court finds that it was not arbitrary and capricious for the agency to decide to take that action with respect to e-cigarettes. So a court agreed with the FDA that it has the power of the authority to follow through on the FDA final rule. It's basically what that means. That pretty much sums up the entire decision in that one little paragraph. That's second. This opinion will lay out the reasons for the court's conclusions And it will also explain why the new rules being applied to e-cigarettes do not violate the First or Fifth Amendments to the Constitution, and why there was no requirement that the agency undertake the sort of formal cost-benefit analysis the plaintiffs claim was omitted here. When all is said and done, the court will grant the agencies a cross motion for summary judgment, and it will deny plaintiffs' motions for summary judgment. That when it says motions, that's consolidated one plus the unique separate motion for summary judgment. Let's take a look at the footnote. On June 8th, 2017, the parties filed a joint notice alerting the court that the FDA has announced that it is deferred, and this is in relation to Stephen on the Vaping Minuteman live show last Tuesday. And he was trying to argue the point that the Nicopure Labs decisions, the court decision, will be delayed because of a 3-month extension. And I was trying to explain to him that a motion to the court by Nicopure Labs, Right to Be Smoke-Free Coalition, even the FDA, was not to defer her decision, but rather to, take her time and then issue her decision whenever. Of course, Steve was giving me an argument on that, and this here will speak to it actually. On June 8th, 2017, the parties filed a joint notice alerting the court that the FDA has announced that is deferring enforcement of all future compliance deadlines under the deeming rule for 3 months in order to give new leadership personnel at the department and it's supposed to be a little typo there on her part. It's supposed to be at the Department of Health and Human Services and the FDA an opportunity to more fully consider the issues raised by the deeming rule. While the Right to Be Smoke-Free Coalition believes that the court should withhold its decision on the pending cross motions until the agency's review is complete, no party has moved to stay the action, and nothing in this opinion prohibits the FDA from continuing to work with industry representatives to establish a mutually acceptable schedule for the implementation of the rule. This opinion will refer to the compliance deadlines that are set out in the rule itself, notwithstanding the fact that some of those deadlines have been extended. And that's what I'm saying. The November 8th, 2018 is not an official date. What's official date is in the rule, in the FDA final rule, which is August 8th of 2018. Now, like she even says in this footnote here, like it says, to establish a mutually acceptable schedule for the implementation of the rule. The court is saying that if the FDA, Nicopure, Right to Be Smoke-Free Coalition, or any of the industry can work with the FDA to work out maybe a mutually acceptable schedule, then so be it. The court washes its hands of that. That's between the FDA and the vaping industry. If that happens, it happens. It don't. Let's get down to page 10. I really need to work on this damn color of this damn camera. Hit that. Quite distressing. Very clear though. It's a very clear picture. Not better than the other camera I have. The only way to effectively protect the public health from the dangers of unsubstantiated modified risk tobacco products is to empower the Food and Drug Administration to require that products that tobacco manufacturers sold or distributed for risk reduction be reviewed in advance of marketing, and to require that the evidence relied on to support claims be fully verified. So, all these manufactured finished product dates, especially after August 8, 2016, need to be verified by the FDA, need to be reviewed. They are illegal products, and I'm telling you, I am telling you, these FDA warning letters are going to be flying out the window, and not just on those that are being given vapor products slash e-liquid to those that are under the age of 18. It's going to be for these manufactured finished product dates after August 8, 2016. That's that's why, I'm just telling you right now, Adam Miller and the rest of you guys, you better stop now with these manufactured finished product dates after August 8, 2016. They are going to hang you. Not literally, but, well, maybe a little. No. They are going to civilly, especially Adam Miller of Vaporized Nomads, because he's a domestic manufacturer, they are going to shut him down. You understand that? They are going to take those manufactured finished product date products after August 8, 2016 off of his shelves. And if he does not comply with that, they will take him to court. Take him to court. And he is going to be fined and possibly even imprisoned because of adulterated slash misbranded products that have not been reviewed by the FDA. This is a very serious matter. I don't care what TH says or any of them. They don't know what they're talking about. TH, well, he has some idea about what's going on, I guess. I don't know if he does or he doesn't, to tell the truth. Sometimes I wonder about him anyway. But the point is, this is very, 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 very serious. This is a wake-up call, this court decision. You guys better act legally, or you're going to pay the piper, so to speak. They will be serious repercussions, serious legal consequences to your actions. And on that point, I do agree with TH in his comment. Finally, the statute recognizes that the FDA is a regulatory agency with the scientific experience to identify harmful substances and products to which consumers are exposed, to design standards and to limit exposure to those substances, and to evaluate scientific studies supporting claims about the safety of products, and to evaluate the impact of labels, labeling, and advertising on consumer behavior in order to reduce the risk of harm and promote understanding of the impact of the product on health. I mean, that pretty much sums it all in a nutshell. I don't need to even elaborate on that one. '21 United States Code 321RR1. Neither the Tobacco Control Act nor the Food, Drug, and Cosmetic Act further defines the terms component, part, or accessory. And that's a very good point she made there. Holy crap. That is so... I'm telling you, this judge is mean, man. I'm telling you. She's tough. She's a tough girl. She is extremely tough. I'll tell you what that means in a moment. She doesn't leave any gaps, any gray areas in her argument. In other words, the Tobacco Control Act and the Food and Drug Cosmetic Act defines the terms component, part, or accessory, but doesn't specifically say what they are. It is left up to the deeming authority given to the Secretary of Health and Human Services Department to decide what is a component, what is a part, what is accessory. And he has, right now, Tom Price has a free reign on defining whatever is a component, a part, or accessory. It's amazing. Because the Tobacco Control Act and the Food, Drug, Cosmetic Act does not specifically say what it is. It's left to the deeming authority, and it's left up to the Health and Human Services Department Secretary to decide what it is, what they are. She's tough. I'm telling you, a little thing like that, to put that into our argument is incredible. I'll go down to page 16, a footnote. I got a ways to go here, guys. Sit back and vape. It was pretty easy to read her argument, though. It's very easy to read this. Really very easy, because for one thing, I'm very accustomed to all this language anyway, because it's all I've been reading for the last over a year now. The footnote says the Tobacco Control Act contains other provisions that are important to the protection of public health, such as requiring that tobacco products bear a warning about the addictive nature of the products and banning all flavored cigarettes. But those provisions are not relevant to the issues in this lawsuit. So in the Nicopure Labs and Right to Be Smoke-Free Coalition, they did not raise the whole idea of flavor ban. Maybe they should have, but they didn't. They didn't entertain that in their motion for summary judgment. So therefore, it will be left up to the Congress/FDA, probably the FDA, because Congress is probably going to strip that vaping language out of that H.R. 3268. On to page 20, footnote. Says plaintiffs complain that the FDA has defined component of pork broadly enough to encompass even batteries and software, where they argue that the agency exceeded its authority. But in the deeming rule, the agency specifically explained that it intended to limit enforcement of the pre-market authorization provisions to finished tobacco products, sealed in final packaging intended for consumer use. Therefore, as became clear during the hearing, that is the oral argument hearing back in October 2016, plaintiffs' claim is focused on the application of the deeming rule to open system devices and nicotine-free liquids, and any challenge to the application of the rule to batteries or other parts alone would be premature. So in other words, she's not entertaining the battery standards. And that will be left up to the FDA to do unless there's a separate lawsuit in regards to battery standards, which may very well wind up happening. Where's this line? Nicopure does not argue that the FDA did not have the legal authority to deem e-cigarettes to be tobacco products. And it's true. In their motion for summary judgment, they never stated once that the FDA does not have the legal authority to deem e-cigarette to be tobacco products. And therefore, they never made that argument to the court. And so therefore, we are considered, even according to Nicopure lawyers, the clients they represent, Nicopure / Halo e-liquid and Halo products, that we are considered as tobacco products. They never argued that point in any of their briefs. So that was never challenged in the court. We are considered, according to the court, to this court decision, and throughout all the papers that were submitted to this court, we are considered as tobacco, period, unless Congress goes in there and changes that language in the Tobacco Control Act. Footnote, the complaint also requested a preliminary injunction, but Nicopure never filed the necessary motion, and it later abandoned its request for preliminary relief. So there is nothing stopping anything as far as the FDA final rule in regards to its dates or its provisions or anything. Apparently, they never filed the necessary motion according to local civil rule 65.1. So there will be no injunction on the FDA FOLLY rule in any way. Right to Be Smoke-Free Coalition also requested a preliminary and permanent injunction, but they too failed to comply with local rule 65.1. So there'll be no injunction of any of the dates within the FDA FOLLY rule, or any of the provisions for that matter. And here we go into the Chevron. In reviewing an agency's interpretation of statute, courts use the two-step analysis outlined in Chevron. Step 1 involves determining whether Congress has spoken directly to the precise question at issue. If it has, the court as well as the agency must give effect to the unambiguously expressed intent of Congress. And that is the end of the matter. If the statute is silent or ambiguous on the question, Chevron instructs the court to go on to a second step and determine whether the agency's answer is based on a permissible construction of the statute. An agency's interpretation will warrant deference if it is reasonable. I just wanted to say that in case of those that don't understand why I keep bringing up this Chevron doctrine. This is pretty much it, right there in a nutshell. Throughout its pleadings in this case, Nicopure repeatedly quotes just a portion of the statutory definition of tobacco product in this manner, and omits the portion that includes any component, part, or accessory of a tobacco product. Congress expressly defined tobacco product as a product made or derived from tobacco and intended for human consumption. The majority of Nicopure's products are neither. This leaves a misleading impression, and the deliberate excism undercuts the persuasive force of plaintiff's argument. So, the judge caught that. Meaning that it didn't really help the plaintiffs in Nicopure Labs' Right to Be Smoke-Free coalitions in this particular area of Nicopure. They tried to be sort of, not sneaky, but they tried to imply certain matters, and it did not work in their favor because the judge caught it. While the decision is an important part of the legal backdrop of this case, the Souderer Court's rejection of the drug device provisions of the FDCA, the Food, Drug, and Cosmetic Act, as a basis to regulate e-cigarettes does not answer the questions posed here. Whether a particular category of end products can be regulated as components or parts of tobacco products. Defendants note that the only difference between the products at issue in Souderer, hopefully I pronounced that right, and the products sold by plaintiffs is the fact that plaintiffs manufacture open system vaping devices. And the agency suggests that the court should not be swayed by what it sees as a change in position by the industry. Having insisted in Souderer that e-cigarettes are regulable as tobacco products, manufacturers cannot now avoid that conclusion simply by making their products refillable. Indeed, while the question presented in Souderer was whether e-cigarettes should be regulated as drugs, devices, or instead as tobacco products, the choice plaintiffs offer here is markedly different, whether refillable e-cigarettes should be regulated as tobacco products or, as plaintiffs urge, not at all. The plaintiffs have conceded that most ends products may be lawfully regulated under the Tobacco Control Act. And notwithstanding Souderer, the court must go on to utilize the Chevron analysis to determine, as a matter of first impression, whether the agency has interpreted the statute properly. The threshold determination whether the agency is reading a component or part to include empty open vaping devices or nicotine-free liquids sold separately is consistent with the Tobacco Control Act. Turns on whether Congress has directly spoken to the precise question at issue. The District of Columbia Circuit has explained under the first step of Chevron, the reviewing court must first exhaust the traditional tools of statutory construction to determine whether Congress has spoken to the precise question at issue. The traditional tools include examination of statutes, text, legislative history, and structure, as well as its purpose. So what it's basically saying here, it's pretty self-explanatory, is that when they were looking at the case with Enjoy back in, I believe it was in 2007, I think, 2008, Enjoy is really the ones that really got us into it. I mean, if you really want to be forthright about all this, if you want to blame anyone, blame Enjoy. They're the ones that got us all into this hot soup in the first place. Absolutely. Because the FDA only at that time had the authority to regulate drugs. They didn't have the authority to regulate tobacco yet, because the Tobacco Control Act wasn't signed and or enacted into law until June 22nd, 2009 by Obama. And Enjoy kept on saying, no, we are tobacco products, we're not drugs, and therefore you cannot regulate us. So as Enjoy is the one, if you want to blame any company in this industry, blame Enjoy for putting us in such a hot soup anyway. In fact, Enjoy, the cellular case, is actually the ones that we wound up being termed or defined as tobacco. Ironically, it was our own industry that wound up, in the end, hurting us, as it continuously does anyway in the present. That's where it grew out of as tobacco products. We are regulated as tobacco, not a drug. The FDA in the Enjoy case was saying it's a drug because of nicotine. Nicotine is considered a drug according to the FDA. That's how they regulate nicotine. They regulate nicotine as a drug. That's why Big Pharma has all these nicotine products. Those products are regulated as drugs. But at that time, they didn't have the authority to regulate tobacco, and the Enjoy was saying, you know, we're tobacco. And then, of course, the Tobacco Control Act of 2009, and that was the end of the story there. If you want to blame anyone, blame Enjoy. A lot of the stuff I've read already in other cases, it's amazing. But still, she's something, this Amy Berman Jackson. She is a tough girl. She is a real tough girl. She don't mess around. The DC Circuit has directed reviewing courts to exhaust the traditional tools of statutory construction, including examining a statute's purpose when they embark on the search for the plain meaning of the statute. Here, Congress specified that the purpose of the Tobacco Control Act was to give the agency flexibility in regulating tobacco products, and particularly those products that may be attractive to minors. The list of statutory purposes set out in the legislation includes to ensure that the Food and Drug Administration has the authority to address issues of particular concern to public health officials, especially the use of tobacco by young people and dependence on tobacco, to provide new and flexible enforcement authority to ensure that there is effective oversight of the tobacco industry's efforts to develop, introduce, and promote less harmful tobacco products, and to impose appropriate regulatory controls on the tobacco industry. These unequivocal statements of the intent behind the legislation support the court's finding that the agency's common sense interpretation is not inconsistent with the statutory definition of a tobacco product. Thus, the court finds that the FDA's conclusion that it has the authority to regulate open vaping systems, even if they are empty and packaged alone, is not precluded by the statute and survives analysis under the first step of the Chevron doctrine. So open systems that are, you buy them, let's say you buy a tank. You go to the vape shop, go online, you buy a tank. All right? That is automatically considered a tobacco product, regardless if it has nicotine in it or not, because it goes to the intended use. The intended use is to vape on it, to use it in the whole co-packaged situation, like this particular thing. This IPv5 and the Sense Hercules Plus. If this thing was sold separately and empty, the intended use is what? What, are you going to vape on an empty tank? No. You're going to put it all together with all of this and then vape on it. Okay, in fact, I'm going to vape on it now. I love this little setup here. This is a great setup. Looks sharp too, doesn't it? It's heavy as a rock, but it's a great. I love the way it looks. Backfired on me. The old famous indoor smokers. Get the juice out of there. Get the juice out of there. That's how I learned that little trick from indoor smokers. A little too much e-liquid went into those coils a little too fast. There are 0.2 coils on there. It reads out as a 0.24. You could vape it from 35 to 80 watts, but I have 60 watts. Might be a little too much. And I just put this coil in about like a few days ago, so it should be good to go, but it should last at least 10 days on these coils, but you never know. So the key to this is the Chevron doctrine. There's two prongs, two steps. And the first step is when it's clear language. And what the judge is saying is that the vaping products, open systems as well as closed systems, are very clear. In other words, it's clearly, vaping products equals tobacco products. That language is clear, period. That's why Congress has to go in there and separate us from the Tobacco Control Act. But until that happens, we are stuck with this decision. In the court's view, the ordinary terms component and part are not ambiguous, and the FDA's exercise of its deeming authority to cover the products at issue falls squarely within the limits of the statute. But to the extent the statute is ambiguous for all of the same reasons, the agency's interpretation is based on a permissible construction of the statute, and therefore it merits judicial deference. So she gave the FDA's CTP and this FDA the deference because they had a permissible construction of the statute. It was permissible, it was reasonable, and that was that. And that was a very important paragraph there. That's on page 34, second paragraph. You guys want to take a look at it. I'm going to pause this video in a second and come back, take a little rest, and then come back in about a half hour and do a little more reading after this one little section here. Plaintiffs object to the characterization of an empty ends device as a component on the basis that those devices are separate consumer products that contain neither tobacco nor anything derived from tobacco. But an empty open vaping system is not a generic consumer item with multiple potential functions like a box or a bowl. the purpose of those items might not be evident until the consumer chooses to use them in a certain way. But an open system vaping device is a unique item with a single function, and it is fundamental to the vaping process. You can't vape without it. Therefore, the FDA's interpretation of the term component to encompass an empty open system vaping device is based on a permissible construction of the Tobacco Control Act. And that's what I was saying about Suck My Ma on the other video on the Micro White series, I think 146 and 147. It's very simple. If you buy a tank or an RDA by itself, you can't vape it. You could, but it'd be extremely difficult and defeat the entire purpose. I mean, you stick it in your mouth, maybe blow out, make it into a whistle, maybe. But it's useless to you until you put it on some kind of battery-operated device, as well as until, of course, you put e-liquid in it. So therefore, a component, meaning box mod, 2-mech mod, hybrid 2-mech mod, tank, RDA, RTA, or DTA, whatever have you, is considered a component. The same thing goes with the cotton and the wiring. You can't vape without wire. I mean, you could, but it's extremely difficult. And you can't vape without cotton, though you could try it. Just put wire, like maybe mesh wire. You possibly can vape without cotton, but you won't really enjoy it as much as you ought to. You can also vape probably without a drip tip, but still won't be a very pleasurable experience. And you won't really enjoy it because it'll get very, very hot. So all of those components are considered tobacco products. And like she says, is permissible construction of the Tobacco Control Act. Without the batteries, you're not going to vape anything. Anyway, I'm going to pause this and then I'm going to come back. So I have a page and a half to do here of my notes anyway. And I'm only on 35 pages out of 93 pages of the court decision. So I'm going to come back in a moment and pause this, and I'll be back in about 15 minutes. I'll continue on with what I was doing. Plaintiffs maintain that this aspect of the rule contravenes the Tobacco Control Act. And before addressing the merits, defendants briefly argue that the court lacks jurisdiction to hear this claim. They argue that plaintiffs lack standing because they have not alleged sufficient facts to demonstrate that their liquids are subject to the rule. Defendants also maintain that the claim is not ripe. They point out that plaintiffs do not yet know if the FDA will initiate enforcement proceedings against their non-nicotine-based e-liquids, and that in light of the agency's stated intention to review nicotine-free liquids on a case-by-case basis, any challenge to that aspect of the regulation should wait until the agency initiates its enforcement proceeding. Therefore, the court must determine whether it has jurisdiction before it may go on to assess whether the agency's interpretation of the statute is reasonable. And, it's true. I mean, it's mainly a case-by-case basis in regards to nicotine-free e-liquids. And the FDA will probably hold off on enforcement action in that regard. Her legal argument is very self-explanatory. It's very easy. At least, someone's been reading all this stuff all the time, Especially to my hardcore subscribers, should be able to get most of this very easily. Plaintiff Nicopure has supplied the court with a declaration stating that it manufactures approximately 160 different kinds of nicotine-free e-liquid. and therefore the court finds that it has standing to challenge the agency's decision to regulate these products as part of the rule. It is of little moment that plaintiffs have not specified whether their nicotine-free liquids are or not intended to be mixed with liquid nicotine, since the agency has already specifically stated that it is not bound to take manufacturers at their word. Thus, under the terms of the rule, plaintiffs could be subject to enforcement proceedings if they do not submit their nicotine-free e-liquids to pre-market review process. Now, it's less costly, less paperwork, but they need to register their zero nicotine e-liquids. It says it right there, because like this says, the FDA doesn't trust manufacturers. In fact, I don't trust manufacturers, especially because all these manufacturers have put out manufacturer finished product date products after August 8, 2016. Should show you how wild west all these manufacturers are. They're all full of bunk, actually. They're just exploiting a dying industry. The FDA is going to start to issue all these FDA warning letters and then enforce. It's going to become a whole different ball game in the next month or two. It's not 6 months, not a year from now. Today starts. Defendants argue that plaintiffs do not know whether the FDA will ever initiate enforcement proceedings against their non-nicotine-based e-liquids, and that in light of the agency's stated intention that it will review nicotine-free e-liquids on a case-by-case basis, any challenge to that aspect of the regulation should wait until the agency decides to initiate an enforcement proceeding. So this particular issue with nicotine-free e-liquids is not ripe yet before the court, and therefore it needs to wait to be heard in a court of law until the agency actually starts to initiate an enforcement proceeding, things of that nature. Plaintiffs here are in a similar posture to the plaintiffs in NAHB case. The agency has indicated that its enforcement activities against manufacturers who produce a non-nicotine-based e-liquids will be undertaken on a case-by-case basis. And while defendants ask the court to wait until the agency decides to enforce the statute on a manufacturer of non-nicotine-based e-liquid, the court can determine whether the statute authorizes the regulation of those products in the first instance. The question in this case is not about whether the regulation will apply to a particular nicotine-free e-liquid. The challenge is whether nicotine-free e-liquids can be regulated at all. There may very well be future litigation about whether the agency's case-by-case review was lawful, but that is not the challenge being brought in this case, as I've stated. Possibly, be litigation down the future, but not right now. So the court can determine under Chevron whether the nicotine-free e-liquids at issue are subject to regulation. Plaintiffs advance the theory that because Congress defined tobacco product to mean a product made or derived from tobacco, FDA does not have license to extend that definition to products not made or derived from tobacco, regardless of the circumstances. But plaintiffs are ignoring the applicable half of the statutory definition. The agency is not relying on showing that nicotine-free e-liquids are made or derived from tobacco to justify its authority to regulate them. It contends that a nicotine-free e-liquid is a component of a tobacco product, which is comprised of several components. Now, of course, this will wind up being a case-by-case basis and eventually wind up back into a court of law on this particular issue with nicotine-free e-liquid. But according to the FDA, they're regulating nicotine-free e-liquid as a component, like no different than an RDA, because it does not contain nicotine. This interpretation is not inconsistent with the Tobacco Control Act. The statutory definition of a regulable tobacco product specifically includes any component of a tobacco product. And if an ends device with nicotine or tobacco derivative in it is, as plaintiffs acknowledge, a tobacco product, then a nicotine-free liquid that gets added to the mix to provide flavor or make the inhalation experience less harsh, becomes a component of the tobacco product when it is added. See, flavors are considered components. So even if you take zero nicotine liquid and add it to the flavors, then combined together, they're automatically considered as components. So because plaintiffs have not met their burden to show that the statute unambiguously forecloses the agency's interpretation, the agency's interpretation can be upheld at Chevron Step 1. And plaintiffs have not proffered any reasons for why it would be an unreasonable interpretation at Step 2. So they lost on this. Well, they didn't lose. It depends in the future, and it'll probably be other litigation on that. But as far as the language itself within the Tobacco Control Act, it's very clear. They're basically, the court saying and the FDA is saying that zero nicotine e-liquid, because it's with flavors and things of that nature, it's considered a component and therefore can be regulated by the FDA. Plaintiffs observe that under the terms of the statute, the agency may only regulate nicotine that is made or derived from tobacco, and that therefore it cannot regulate products containing synthetic nicotine. But neither plaintiff seems to manufacture products that contain synthetic nicotine, nicotine that is made or derived in a laboratory or from other non-tobacco sources. So the court does not need to reach the issue of whether the agency may lawfully regulate e-liquids that contain synthetic nicotine. So because Nicopure Labs Right to Be Smoke-Free Coalition doesn't have synthetic nicotine, she's not going to entertain that particular subject matter. Now that may come up in another litigation, in another case someday, but right now she's not going to entertain synthetic nicotine. It's a mute issue before the court. Take a vape here before I read all this. Legal standard. Under the Administrative Procedure Act, the agency's role is to resolve factual issues and arrive at a decision that is supported by the administrative record, and the court's role is to determine whether or not, as a matter of law, the evidence in the administrative record permitted the agency to make the decision it did. A court must hold unlawful and set aside agency action, findings, and conclusions that are arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law, in excess of statutory authority, or without observance of procedure required by law. However, the scope of review is narrow. The agency's decision is presumed to be valid. See, so automatically right off the bat, a court will pretty much say the agency's decision, like in our case, the FDA final rule, is valid. I mean, right off the bat. And then she or he will, the judge will work down from there. And the court must not substitute its judgment for that of the agency. In other words, she cannot rewrite law. A court must be satisfied, though, that the agency has examined the relevant data and articulated a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. The APA dispute is justifiable. I don't really have to go into all that. But anyway, the legal standard, as far as Administrative Procedures Act, is that this court is saying that the FDA did not act arbitrarily, capricious, of an abuse of discretion, otherwise not in accordance with law. The agency argues that its decision to deem is so committed to agency discretion that it is unreviewable. It points to the deeming provision of the Tobacco Control Act, which gives the Secretary of Health and Human Services the authority to apply the Tobacco Control Act's provisions to any other tobacco products that the Secretary, by regulation, deems to be subject to the Tobacco Control Act. And it argues that Congress's choice of the deferential word deems and the absence of any standard beyond the requirement that the product meet the definition of tobacco product demonstrate that Congress committed the exercise of this authority to the agency's broad discretion. So Congress left it up to the Secretary to deem whatever, pretty much whatever there is as a tobacco product within reason. And according to this court, at that time, the Secretary of the Health and Human Services Department, Sylvia Matthews Burrell, had deemed vapor products as tobacco, and therefore, according to this court, it's within reason or within the law or within the statute of the Tobacco Control Act. In light of the deference that the court must give the agency on administrative procedures review, the court finds that there is a rational relationship between the facts found and the choice made. The court's conclusion is buttressed by these congressional findings in the TCA, which apply with equal force to the regulation of e-cigarettes. Nicotine is an addictive drug. This all comes out of the Tobacco Control Act, by the way. Virtually all new users of tobacco products are under the minimum legal age to purchase such products. Tobacco advertising and marketing contribute significantly to the use of nicotine-containing products by adolescents. Because past efforts to restrict advertising and marketing of tobacco products have failed adequately to curb tobacco use by adolescents, comprehensive restrictions on the sale, promotion, and distribution of such products are needed. It is in the public interest for Congress to enact legislation that provides the Food and Drug Administration with the authority to regulate tobacco products and the advertising and promotion of such products. It is essential that the Food and Drug Administration review products sold as distributed for use to reduce risk of exposures associated with tobacco products, and that it be empowered to review any advertising and labeling for such products. It is also essential that manufacturers, prior to marketing such products, be required to demonstrate that such products will meet a series of rigorous criteria, will benefit the health of the population as a whole, taking into account both users of tobacco products and persons who do not currently use tobacco products. That pretty much sums up that Tobacco Control Act. Go down to footnote. Now this, I spoke about this, a lot of people were saying, well, at that time in Congress when they passed the Tobacco Control Act, that it was not about, or they never spoke about electronic cigarettes, when in fact, I spoke about this several times, Congress was aware of electronic cigarettes. And that's probably one of the reasons why they put the deeming authority in there, because eventually they're going to deem, and they deem electronic cigarettes as tobacco products. The other thing is, during this time when this legislation was going on, they had the Enjoy case, when they were trying to decide, is electronic cigarettes or vapor products, or are they tobacco, or are they drugs? Congress was well aware of what was going on in that case. So, and this is in the congressional record. See, it says here, congressional record. That's what that means. This abbreviated form is congressional record. So anyway, the legislative history reflects that Congress was well aware of the advent of e-cigarettes at the time that the TCA was passed. Representative Beyer stated, in the marketplace right now, there are many different types of products. You have an electronic cigarette whereby it's a nicotine delivery device. Representative Beyer also expressing concern that these new innovative types of nicotine delivery devices could not make their access to the market. Senator Burr stated, then we have a new category called electronic cigarettes. It actually runs off a battery. It extracts the nicotine and delivers it into the system in a totally different way than the tobacco-headed cigarette. Indeed, Senator Burr seemed to propose that all electronic cigarettes should be grandfathered into the substantial equivalence pathway. The statement of Senator Burr, there are electronic cigarettes and other products that have less risk. All those products in February 2007 were not in the marketplace. They are banned. They are eliminated. What are we asking the FDA to do? We are asking them to grandfather 3 categories of products and let all adults who choose to use a tobacco product choose from the most risky categories. Any claim that the proposed Tobacco Control Act reduces the cost of health care is only because we have grandfathered in smokers who will die sooner, not that we have allowed them a pathway through this bill to ever experience not only products that are currently on the marketplace that reduce the risk from 100% to as low as 1%, we have completely eliminated any additional innovation in product in the future. The fact that Congress passed the Tobacco Control Act in its current form, notwithstanding the concerns raised by Congressman Beyer and Senator Burr, provides further support for the conclusion that the Secretary's decision to deem e-cigarettes to be tobacco products, and therefore subject to pre-market review, is reasonable and fully consistent with the intent of the statute. And this is extremely important. The points, we're screwed. Forget it. Forget it. We are in serious, serious trouble. Serious. And Congress is not going to change the language in the Tobacco Control Act. This is extremely important what she said here. This judge is, her IQ is extremely high. Too bad we didn't get a judge that didn't have such extreme intelligence. She has superior intelligence, extremely intelligent judge. And I said this before in other videos on the FDA final rule, that she does not let anything pass her. And anything that she's going to speak to is going to be in those footnotes. That's why I've been reading these footnotes, because these footnotes, she is a, excuse my language to the judge, but she's a son of a bitch when it comes to these footnotes. I'm telling you, she is tough when it comes to footnotes. She does not let anything pass her. Nothing. She's a very extremely deliberative judge. Very well experienced, very well educated. She thinks it all out. She's no dummy. Unfortunately, she ruled in favor of the FDA. I wish if she had ruled in favor of us, it would have stuck really well, especially when appeal. But because of, unfortunately, she didn't rule in favor of us, doesn't help us any. But the chances of this being reversed on appeal is very slight, guys. I'm telling you. The industry will spend millions of dollars for an appeal. And it probably, I hate to be the Debbie Downer, but I hate to tell you, it probably will be affirmed, that decision. You have in the House of Representatives, you have over 400 representatives. and in the Senate you have 100. And you only have one congressperson, Congressman Beyer, I think it was a representative, yeah, Representative Beyer in the House of Representatives, and one senator that spoke, and Senator Burr was like the only one that actually spoke pretty much in favor of vaping. But these are only 2 congresspeople that spoke about electronic cigarettes out of over 500 congresspeople. And so surely the intent, because they were aware of it as they debate this in Congress at that time, back in 2008, 2009, Congress was certainly aware of electronic cigarettes, and yet still permitted the language of the deeming authority to remain, and didn't put any provisions in the Tobacco Control Act to save us in any way. Just put down deeming authority, let the secretary decide what he or she will do, and leave it at that. And this judge, you can't blame her. She is restricted in writing any law. She can't write law. She can only interpret. In this particular case, or any cases for that matter, she is going by the record. And congressional record shows that the only 2 congresspeople that were talking, one was talking wholly in favor of the vaping industry, and the other one just sort of brought it up. But these are only 2 people out of over 500 congresspeople. And like she stated, the fact that Congress passed the Tobacco Control Act in its current form, notwithstanding the concerns raised by Congressman Beyer and Senator Burr, provides further support for the conclusion that the Secretary's decision to deem e-cigarettes to be tobacco products, and therefore subject to pre-market review, is reasonable and fully consistent with the intent of the statute. In other words, if maybe you've had 300 congresspeople back in 2008, 2009 speak up for vaping products, then yeah, then this FDA final rule probably could have been found unreasonable, at least in this area. But you only had 2 people. And Congress was aware of all this. It's in the congressional record. They debated in open forum for the public to even watch. I mean, they had C-SPAN, not so much on the internet. I mean, they had it in those days on the internet, but not many people watched it. It's mainly on your TV sets. So she makes a very good point here as far as the intent of the statute. The intent of the statute was that the deeming authority gives the Secretary of Health and Human Services Department to decide in its finality form, I guess you could say, that vapor products are tobacco products, period. And unless Congress changes that, no judge in any court will touch that. They won't do it. They won't do it. Sorry to tell you that. I wish it was different, but because I had thought maybe it'd be partial, you know, grant us modified risk claims PMTA, grant in part, denied in part. That's what I thought. I didn't think we'd have 100% win on those 2 claims, but at least granted in part. But she didn't even do that. And that's what I was afraid of, was the Chevron doctrine, which the FDA has for the court. I mean, every federal agency will invoke that automatically in any case brought against the federal government or any agency, especially agencies. I shouldn't say federal government. Most of the time it's used only with federal agencies. Anyway, second paragraph. Now this is interesting here. This is very, she sort of implies it. Very interesting, but I caught it though. Anyway, the record before the agency included a substantial volume of comments submitted by public health organizations such as the American Academy of Family Physicians, the American Academy of Pediatrics, the Cancer Action Network, the American Heart Association, the American Lung Association, and the American Psychological Association, all of which urged the agency to strengthen and make comprehensive the proposed deeming rule in order to prevent the manufacturers of tobacco products from designing and marketing their products in ways that undercut the full potential of the Tobacco Control Act to achieve its life-saving objectives. Now, this is interesting. I mean, that's pretty straightforward. We know all about these organizations. I spoke to about them. They have their agenda or whatever. But what's interesting about here is prevent the manufacturers of tobacco products from designing and marketing, but mainly here. Bring anyone to mind? And I've said before that if you take the designer of whatever vapor product there is, you take the designer out of the picture, you have nothing to manufacture. That's an implied statement. I'm not going to go there, but it certainly is actually written right into her ruling. Leave it at that. Won't go any further than that. Let a judge decide that. I'm sure it will happen eventually. 54. Needed some rock star to wake me up, I tell you, for this decision. This goes on for a while here, but I'm going to read it and then I'll talk about it. Nicopure argues that the agency failed to meaningfully consider alternatives to the pre-market review requirement, including 3 options in particular. First, Nicopure contends that the agency should have waited to deem until the agency had sufficient data to reach a conclusion one way or the other regarding the health effects of vaping products before choosing whether and how to regulate them. Second, Nicopure contends that the agency should have adopted the European Union's approach to regulating vaping products, which includes many of the same requirements but does not require pre-market review. Third, Nicopure faults the agency for failing to consider crafting a streamlined pre-market review process for products such as vaporizers that fall on the safer side of the risk continuum. That's what I thought you would do, at least in part, grant that this whole line right here of crafting. That's what I thought she would, at least grant us in part for that, but didn't happen at all. The law is clear that plaintiffs are not entitled to the regulatory alternative that they prefer. Rather, the court must give appropriate deference to the expertise of the agency and ensure that the agency considered the alternatives proffered by the plaintiffs and rejected them for reasons that are rational. And it bears repeating that pre-market review is a creature of a statute and not a new regulatory requirement dreamed up and imposed on ends manufactured by the FDA. It's contained within the Tobacco Control Act. The European Union model would subject manufacturers to disclosure, advertising, good manufacturing practices, misbranding, and other requirements, but it would not require manufacturers to obtain a pre-market review. Whatever one might think about the benefits of the European Union approach as a policy matter, a rule that adopted that approach would have been contrary to the Tobacco Control Act, because the Tobacco Control Act requires that all tobacco products must undergo some kind of pre-market review. Plaintiffs argue that the agency could exercise enforcement discretion and that it exercised similar discretion allowing for an extended compliance schedule. There is certainly nothing in the statute or the rule that would bar the parties from engaging in constructive negotiations to establish a more manageable timeline. But the fact that there may be reasons for the agency to be flexible when implementing the pre-market review requirement does not mean it was unreasonable for the agency to decline to adopt the European Union approach and eliminate pre-market review altogether. And before I go on, I actually spoke about this on the FDA final rule. Like this whole thing with CASA. Several weeks ago, CASA actually has this petition with the FDA to nullify the FDA final rule. That's not going to happen. I can guarantee that, especially after this ruling. But even then, I knew it would never happen, because there is actually within the Federal Register, and I speak about this in a FDA final rule video, that the FDA actually permits anyone to approach them to try to work things out. This is outside of this petition. In fact, the petition is usually used by drug companies in order to avoid a lawsuit, to avoid going to court over it. But like it says here, that would, from engaging in constructive negotiations to establish a more manageable timeline. And that's between the FDA and the vaping industry. That certainly can go on. It says it right in the Federal Register. The FDA has certain provisions within the Federal Register that speak exactly to that line. Just a bunch of lawyers made a lot of money, though. Kohler and Heckman really screwed this one up. Holy crap. They made a lot of money, but they screwed it all up. We just could not get past that Chevron doctrine, and that was that. It was that simple. Anyway, continues on. Similarly, plaintiff's argument about a streamlined pre-market review process finds little support in the Tobacco Control Act, and the agency appropriately rejected that argument as well. As the agency concluded, all tobacco products going through the pre-market pathway must meet all the requirements for a pre-market authorization in Section 910 of the Food, Drug, Cosmetic Act before FDA can issue such an authorization. Finally, the agency did consider the suggestion that it should defer the deeming regulation indefinitely, and it rejected it, finding that it did not have to meet a particular public health standard to deem tobacco products. And it supported its decision by setting out the public health benefits of the rule in great detail. Yeah, and that's all contained in the FDA final rule, that great detail, by the way. Actually, this here is quoted right out of the FDA final rule, Federal Register. That's page number / section. So, in other words, the FDA doesn't have to streamline. The Tobacco Control Act is in stone, and until it's reversed by Congress itself, any of the language within the Tobacco Control Act, to be quite blunt, the FDA can do bloody whatever bloody they like to, however the English would say that. That's a really naughty phrase from the English, right? We can do bloody well what we like. We're a bunch of swashbucklers. So that's that. And that's pretty much it for the end of the pre-market tobacco application process. She gave all the power to the FDA to do whatever they like pretty much with the PMTA. In fact, the FDA, even though they can negotiate with the vaping industry, ultimately it's up to the FDA to decide what they want to do with that or not. This is a seriously bad decision for the industry, or our community for that matter. And this is going to be affirmed on appeal. Mark my words on it. This is going to stick, man. Meanwhile, a lot of appellate court attorneys are going to make a huge amount of money. They'll make like $1 to $5 million for an appeal in this case. And so therefore, all that fair cloth lawsuit, lost art liquids, Alabama vape shops / Cyclops vapor, just piss, just forget it all about it. So if my advice to Vaping Legion Network, save your money. Don't give any more money to Larry Faircloth lawsuit. You're going to lose. Period. End of story. She really, I mean, she is extremely tough. I knew that of her. I've said that before on the FDA Final Rule channel. But I thought she'd at least grant, in part, at least some modified risk claims and PMTA, but not even that. Not even that. Like, she even used the phrasing that I've been using. Like the streamlined. I've been talking about streamlined, revamped the PMTA. Won't even budge on that. It was Congress that set the grandfather date in the Tobacco Control Act, and right to be smoke-free has not pointed the court to any authority for the proposition that the agency can ignore a statutory command. So they have to, in other words, the vaping industry has to comply with Congress, with the Tobacco Control Act. Right to be smoke-free argues that when viewed in the Tobacco Control Act's overall statutory context, it is apparent that Congress did not intend for the February 15, 2007 grandfather date to be strictly applied to all categories of deemed products. But the starting point for interpreting a statute is the language of the statute itself. See, she's applying that first step to the Chevron doctrine, which is clear language. You know, she did not rewrite the Tobacco Control Act in any degree. She applied that across the board in this case. She is taking the Tobacco Control Act at its face value, and applying it to this case. Period. End of story. The statute unambiguously points to a specific date, February 15, 2007, and it contains no exceptions for items deemed to be tobacco products in the future. There, simple. And quote, and she cites the United States Code, which is the Tobacco Control Act. Tobacco Control Act, the Act of Congress, is codified into the United States Code. The United States Code is all congressional acts, all of the acts of Congress. So it says, contains no exceptions for items deemed to be tobacco products in the future. That's 21 United States Code 387JA2A. There are no exceptions to the predicate date, February 15, 2007. The only one that can change that is Congress. And this is when, you know, she gets a little, you know, nice, but she's still a judge, and she's going to tell you like it is. While the court is sympathetic to right to be smoke-free's policy argument that as new products come to market, a grandfather date will become obsolete. The path forward is to seek an amendment to the statute, which is already underway. As they stated in the oral argument, the court, isn't your problem with Congress and not the agency, and aren't you already working on that right now? And Council for Smoke-Free, Right to be Smoke-Free Coalition, we are. There are two bills in front of Congress right now, and they were referring to the HR 2058, and at that time this was October 2016. So HR 2058 was sort of, you know, still hanging around in a way, but it really was dead. And the Cole-Bishop Amendment. That's what they were referring to. So basically she's saying that if you have a problem, the path forward is to seek an amendment. You want to change anything in the Tobacco Control Act, you've got to get an amendment onto it. But what are they doing with this vaping language? flavor bans, battery standards, and as far as a predicate date, they are not going to allow a hybrid 2-mech model on the market. That's not going to happen. Sorry about that. In fact, that'd probably be thrown out. Now, you know, Vaping Minuteman may like to hear this. Even though I do not like the language within the HR 2194, in the year 2018, that probably will be the best bet we have. Unfortunately, it's going to wipe out a lot of the fully mechanical box mods, 2-mech mods, hybrid 2-mech mods, and things of that nature. But the Hunter legislation may very well get passed and enacted in Congress in time before either August 8, 2018, which I doubt that, but maybe before November 8, 2018, though the FDA certainly can fulfill the official date in the FDA final rule, that is August 8, 2018. But even though I don't like the language in the Hunter legislation, believe it or not, that is really our best bet, because at least separates us from the tobacco products. Now, of course, those standards, those vapor product standards, are still left to the quote-unquote deeming authority of the Secretary of Health and Human Services Department. But when you really think about it, maybe it's, you know, the best we can do. So the statute is clear, and FDA had no power to change it. So Right to Be Smoke-Free Coalition's challenge to the grandfather date fails. Now, I knew that one. I told you that already. That's an easy one. 52nd, 57 for a second. There's another big one here. So we want to go to this. So we got first and second, yep, and the footnote. This is true notwithstanding the legislative history that reveals that this very issue was raised at the time the statute was under consideration. And it's true. The statement of Senator Burr back on June 9th, 2009. The Tobacco Control Act of 2009 was signed into law by Obama on June 22nd, 2009. Senator Burr stated on June 9th, 2009, in regards to the grandfather clause, the footnote 27, which is this right here. You look at the 27, and the footnote is that according to legislative history or the congressional record, it shows that the issue of the grandfather date was raised, and that was that. 59, coming to an end here, maybe another half hour, we should be done this. 59, the FDA specifically took that issue into consideration. Plaintiffs' concerns are somewhat premature. The deeming rule recognizes that in some cases it may be possible for an applicant to obtain a pre-market review authorization order without conducting any new non-clinical or clinical studies where there is an established body of evidence regarding the public health impact of the product. And on the day that the agency promulgated the deeming rule, it also issued a draft guidance on pre-market review applications. The guidance recognizes that a marketing authorization may issue if there is an established body of evidence regarding the health impact individual population of a product or similar product that can be adequately abridged that products such as data from the published literature or government-sponsored databases. Now, you hear a lot of people, like especially Grim Green and these characters, always saying, "I would submit my products, but I don't know what the FDA expects me to, provide them. They never was clear on their PMTA." That's bullshit. That's absolute bullshit. In fact, here you have the IQOS going through the FDA pre-market tobacco application process as well as the modified risk claim process. And they were relying upon this draft guidance that she was just cited in her court decision. Says it right here. Draft FDA guidance for industry pre-market tobacco product applications for electronic nicotine delivery systems. May 2016, AOR 28350. This draft guidance right here, in fact, I spoke about that extensively in 2 parts on the FDA Final Rule channel. Industry knows exactly what is expected of them. Will they be able to fulfill it? No, only the big guys can. Maybe possibly Cosmic Fog, maybe a few others if they want to spend millions of dollars, but you know, the chances of them being approved, well, that's anybody's bet. In count 3 of the Nicopure complaint and in count 8 of the right to be smoke-free complaint, plaintiffs allege that the deeming rule violates the Administrative Procedures Act because the agency's cost-benefit analysis was insufficient. But the agency was not required to undertake a cost-benefit analysis when it implemented the statutory deeming provision. And even if some cost-benefit analysis was required, the agency did some analysis in this case, and there is no legal authority for the proposition that the court has the authority to review it de novo, as plaintiffs seem to be asking it to do, because the balance struck by the agency was reasonable and the court finds that the cost-benefit analysis was adequate. And I did this whole thing on the FDA Final Rule channel, and I actually showed you in the FDA Final Rule where they did some of that cost-benefit analysis. See? Some. And that was the end of that. I'm not going to get heavily into that cost-benefit analysis. Plaintiffs have scoured the rest of the statute, though, and they point to one of the 10 stated purposes of the Tobacco Control Act: to impose appropriate regulatory controls in the tobacco industry. They argue that the use of the word appropriate in the background section of the statute requires the agency to evaluate costs when exercising its authority under the deeming provision. But plaintiffs have not pointed to any legal precedent that would authorize a court to add limits to a statutory provision that contains no limits simply because the word appropriate can be found in another part of the legislation, much less any case law that would imply statutory prerequisites from a general introductory statement of purpose. And then she cites a case. She is so intelligent, this woman. Holy crap. She should be a professor in a law school. You know, sometimes they do that, you know. She's a highly intelligent girl, this Amy Berman Jackson. And she's not that bad looking either, I'll tell you that. Not bad looking at all. Well, George Burns for you. Actually, that's actually Groucho Marx, but never mind. Anyway, but the point here is plaintiffs have not pointed to any legal precedent. See, even though they did that, and I thought that was really rather, not stupid, but they implied it, and it was too, it was like almost innuendo in a way. It wasn't clear enough when they applied this whole thing about the appropriate aspect of their language. I think it was a sneaky thing that Nicopure Labs had attempted in their memorandum to the motion for summary judgment. They should have not toyed around with just one little word out of the entire Tobacco Control Act, or out of the FDA Final Rule. That was actually out of the Tobacco Control Act. And I actually stated before in the video when I did the motion for summary judgment that they were going to fail on that, and they did fail. You can't just take one little word and imply that it means something. It's ridiculous. They were just like Nicopure Labs and Right to Be Smoke-Free Coalition was just throwing as much as they could at the wall. Hopefully something will stick. Unfortunately, nothing stuck. You need to get new lawyers. take new, fresh eyes on this whole situation is what I'm saying. They need lawyers to new, fresh eyes. They do have appellate lawyers in the Nicopure, in the Covington law firm, as well as in the Keller and Heckman law firm. They have appellate circuit court attorneys, okay, that just strictly deal with the appeals process. But you know, not that they ever listen to me, but I would prefer to see actual different law firms look at this, hopefully with fresher eyes. But her decision is so tight that it'd be very, very difficult to tear it apart on appeal. She's one tough girl, and I actually stated that several times, you know, in the FJ final rule. That's why I kept on saying in the last 2-3 months that it'd probably be granted in part, denied in part, because I knew that she's going to be tough, but I didn't think she would deny it all. That's just incredible. So I'm not going to get into the cost-benefit analysis too much. Down page 72. In its equal protection claim, a Right to Be Smoke-Free Coalition objected to the fact FDA treats ENDS products the same as traditional tobacco products, even though ENDS present a lower and different risk profile than cigarettes. Right to Be Smoke-Free contended that its right to equal protection had thereby been violated because Congress has treated differently situated products in a similar manner. This turns the Equal Protection Clause on its head, but Right to Be Smoke-Free Coalition abandoned the claim by failing to mention it in their summary judgment papers. And that was a huge mistake. And they can't raise this on appeal. This is different. Be a different claim. They can't raise that, so it's over. It's a shame what they did. That was a huge mistake as far as the Equal Protection Clause. Because what they're saying is that Congress has treated differently situated products in a similar manner. In other words, we know combusted cigarettes kill you. Vapor products have yet to kill you. They're being treated the same, even though they really act differently. But they fail to mention it in their summary judgment papers. That was a huge mistake on Right to Be Smoke-Free Coalition's lawyers' part. That's Keller and Heckman, and they're a multi-billion-dollar law firm. You'd think they'd have that down pat, but apparently they screwed that one up. They only have themselves to blame on that one. Count 3 of the Right to Be Smoke-Free complaint alleges that the TCA, not the deeming rule, violates the Equal Protection Clause and Right to Be Smoke-Free's right to substantive due process. Since the Right to Be Smoke-Free Coalition has abandoned the equal protection argument, only the due process argument remains. The due process argument is premised on the allegation that Congress has acted irrationally by declining to tailor the pre-market review process to ENDS products. The Due Process Clause provides that no person shall be deprived of life, liberty, or property without due process of law. The first inquiry in every due process challenge is whether the plaintiff has been deprived of a protected interest in property or liberty. Fundamental liberty interests are those that are objectively deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if they were sacrificed. For a law to permissibly infringe on an individual's fundamental liberty interest, it must be narrowly tailored to serve a compelling government interest. By contrast, when a law infringes on a non-fundamental liberty interest, it will be upheld unless there is no rational relationship between the law and some legitimate governmental purpose. It bears noting that Right to Be Smoke-Free Coalition has not pointed to any fundamental right or liberty interest affected by the Tobacco Control Act. But when one applies the rational basis test that Right to Be Smoke-Free Coalition concedes is appropriate, the tobacco control passes the muster. So what they're basically saying is that as far as this compelling government interest in regards to property, because they're mainly dealing with property, liberty to a degree, but mainly property, they can't apply that particular section of the United States Constitution, Amendment 5, because the Tobacco Control Act passes muster. So I'll just continue so you understand it. Right to Be Smoke-Free Coalition asked the court to find that the Tobacco Control Act is unconstitutional because it creates a pre-market review system that plaintiff feels it will never be able to satisfy. But rational basis review is not a license for courts to judge the wisdom, fairness, or logic of legislative choices. And courts must uphold legislation even if the classification involved is, to some extent, both under-inclusive and over-inclusive. Here, a rational basis can be discerned on the face of the Tobacco Control Act. Although we are by no means restricted to the stated reasons for passing a law in our search for a rational basis, we need look no further than the statute itself to discern three rational bases for the law. Congress set forth a number of rational reasons for the pre-market review requirement in the purposes section of the Tobacco Control Act. To authorize, I have a gnat flying around here, to authorize the Food and Drug Administration to set national standards controlling the manufacture of tobacco products, to provide new and flexible enforcement authority to ensure that there is effective oversight of the tobacco industry's efforts to develop, introduce, and promote less harmful tobacco products, and to ensure that consumers are better informed, and to impose appropriate regulatory controls on the tobacco industry. Because the Tobacco Control Act has a rational basis, judgment will be entered for defendants on Right to Be Smoke-Free's due process challenge, because they have a rational basis based upon these particular areas. So it gives the FDA power under the Tobacco Control Act to have, because it gives these here that I've just read off, are the reasons, or the rational reasons for the pre-market review requirement. So they even fill in the First Amendment. Man, it's terrible, terrible, terrible. Just a little more. I know this is just bumming you guys out, but, well, facts are the facts, right? To the extent the Tobacco Control Act regulates speech directly, it is well established that the Constitution accords a lesser protection to commercial speech than to other constitutionally guaranteed expressions. See, and that's very important here. Lesser protection to commercial speech, like vape shops, online and offline. In Central Hudson, the Supreme Court established a four-part test for determining whether the regulation of commercial speech violates the First Amendment. The court is required to ask, is the expression protected by the First Amendment? Is the asserted government interest substantial? So does the regulation advance the governmental interest? And is the regulation more extensive than is necessary to serve that purpose? Supreme Court has engaged in considerable debate about the contours of First Amendment protection for commercial speech and whether Central Hudson provides a sufficient standard. It has continued to utilize the Central Hudson framework in the commercial context. The court also concludes that the TSC, or Tobacco Control Act's regulation of modified risk statements in this commercial setting satisfies Central Hudson. Both aspects of the statute are now extended to electronic nicotine delivery systems by virtue of the deeming rule, directly advance a substantial government interest, and neither is more extensive than necessary. So, as far as the modified risk claims, well, according to this court, and she's strictly going by what the law is, by case law, by U.S. Supreme Court rulings. She's saying that we are unable to say that vaping products are less harmful for you than combustible cigarettes, even though vapor products have yet killed anyone while vaping. Oh, well, the modified risk claims may possibly have a chance on appeal, but that's just an extreme possibility. I don't want to put anything out there like, no. I mean, her decision is tight. I mean, I don't think anything is going to survive on appeal for the vaping industry. The regulation of pure conduct does not ordinarily implicate First Amendment concerns. While the Supreme Court has applied First Amendment scrutiny to a statute regulating conduct which has the incidental effect of burdening the expression of particular political opinion, the court has emphasized that this doctrine has boundaries. Just go a little longer here. One paragraph. The sample ban is not part of a broader restriction on the marketing of e-cigarettes and is not aimed at whatever minimal communicative impact the distribution of e-cigarette samples might have. Instead, it is focused on conduct. A means of distribution of e-cigarettes presents a particular risk of providing the product to underage users. I spoke about this on the FDA Final Rule channel. It actually says that in the FDA Final Rule that free samples is not so much speech. It's not a protected speech under commercial speech or even private speech, but it's conduct. You're giving something to someone. It's a conduct, and that is not protected under the U.S. Constitution in any way, shape, or form. Coming almost to the end here, guys. For these reasons, the court concludes that the distribution of free samples is not sufficiently expressive to constitute protected speech, and that the regulation promulgated by the FDA in accordance with the instructions set forth in the Tobacco Control Act is a regulation of conduct with, at most, an incidental burden on commercial speech. This means that if the First Amendment applies at all, O'Brien is the appropriate test, and then she applies that particular case. The Supreme Court took this approach in Lord Tobacco. Yeah. Anyway, I'll read that. In Lord Tobacco Company versus Riley, when it applied O'Brien to a Massachusetts sales practices regulation because Massachusetts seeks to regulate the placement of tobacco products for reasons unrelated to the communication of ideas. The court held the means chosen by the state are narrowly tailored to prevent access to tobacco products by minors or unrelated to expression and leave open alternative avenues for vendors to convey information about products and for would-be customers to inspect products before purchase. For the same reasons, the restrictions on distributing free samples withstand First Amendment scrutiny. But even if one were to conclude that the ban is a regulation of speech, the legislation also satisfies this central Hudson factors. So it's mainly conduct, and commercial speech is not protected like just regular private speech is. So we lost on that claim as far as modified risk claims are concerned / free samples. Well, this has to do with free samples. It can also be applied to, no, actually it's just applied to free samples. I was going to say modified risk claims, but that's, I mean, that has to do with freedom of speech. It doesn't have to do with so much with conduct. Anyway, I got that. So it's 89C. Tough girl. This tough girl. I'm telling you. Man. If anyone's going to store a woman's world, you know, you always hear it's a man's world, you know. If anyone's going to start a woman's world, she's going to be the leader of it. I tell you, this Judge Amy Berman Jackson. Anyway, the Tobacco Control Act requires manufacturers to obtain agency pre-approval before it introduces into interstate commerce any tobacco product, which represents explicitly or implicitly that it is less harmful than other tobacco products, that it contains a reduced level of a substance or presents a reduced exposure to a substance, or that it is free of a substance. Plaintiffs contend that the Tobacco Control Act violates the First Amendment as applied to them because it prohibits them from making truthful and non-misleading claims about some of their products without agency pre-approval. And they argue that while the statute in theory only restricts modified risk claims, in practice it effectively produces a total ban because the FDA has never approved a modified risk tobacco product application. Plaintiffs insist that the FDA's argument rests on the faulty premise that the tobacco and vapor industries warrant the same treatment with respect to the modified risk restrictions. But once again, that premise was built into the statute by Congress, and the need to protect the public from unsubstantiated health claims applies with equal force to no matter how the nicotine is being delivered. So Congress, if you're going to blame anyone for this whole debacle, blame Congress. Blame those senators and representatives of the House for all this language that is contained in the Tobacco Control Act back in 2008, 2009. They're the ones we should be clamoring on about. Any senators or representatives in the House that are still there on July 21st, 2017, any of them that was in Congress in 2008, 2009, they're the ones that we should be writing to. The ones that actually were pro the Tobacco Control Act. Of course, Casal's not going to tell you any of that crap. This is about 2 little things left, and that'd be it. Notwithstanding plaintiffs' rhetoric, that's a real, I don't know if it's really a cheap shot, but she's basically saying to the lawyers, excuse my language, you fucked up. She didn't buy the rhetoric, the little tricky phrasings and all this other crap. In other words, it was just rhetoric and nothing else, nothing more than that. That it was just the arguments that they made to the court definitely do not bear out at all. Did not help the case move forward. We'll fire. Deal with that later on. All right, will not fire. The arguments from the lawyers for plaintiffs' attorneys, Nicopure Labs Right to Be Smoke-Free Coalition. All it is rhetoric. That doesn't fly in a court of law. No fancy pants stuff going on in her court, I can tell you that. Anyway, notwithstanding plaintiffs' rhetoric, this provision does not ban truthful statements about health benefits or reduced risks. It simply requires that they be substantiated. So the court agrees with the Sixth Circuit that the modified risk provision directly and materially advances the government interests in preventing manufacturers from making false or misleading claims about the products, and it passes muster under the First Amendment. She loves the word muster, but I've seen that in other court rulings, so it's not just her. Conclusion: for all of those reasons, the court will deny plaintiffs' motions for summary judgment, and it will grant the agency's across motion for summary judgment. A separate order will issue. Amy Berman Jackson, United States District Court, date July 21st, 2017. And you know, I slept in this morning, so I didn't wake up until about 11. No, it was a little later than that, actually. I wake up until, yeah, it was somewhere like around 11 or noon. And then I did something, and then I came back to the computer and I said, you know, let me just check to make sure, because I check every day as far as this court decision. And bam, there it was. I was like, holy shit. I knew it'd be any day. It could be, as I've been saying, it'd be any day. I knew it'd come out in 2017, but I didn't know when. So there we are, guys. The chances of this succeeding on appeal, we're in serious trouble, I'll just tell you that. I really did think the court would at least partially grant us something. Didn't even do that. And I will put the United States District Court, District of Columbia link, like I did on the other video. I'll put the link where you can get the court decision at. You can sort of read along as I'm reading it, or read it by yourself, or whatever have you. You just click OK. Like here, let me bring it up for you. Like so. See, I have it bookmarked up here. So I just click on it, and then you hit OK. I mean, not OK. You hit go, and it will say 2017 when you click on the link, and you hit go, and then all the decisions come up. And there's a lot of decisions came up on July 21st. By the way, I'm gonna do this as a sort of an afterthought. But anyway, in regards to CASA. But so, and there it is. When I saw that popped up on the screen right there, I was like, holy crap, holy crap. There it is. You know, it's clear as day. It's clear as a blue sky. So I put up a video real quick, under a minute, to let you know that I got the decision. I'll be speaking to it. I'd like to share something with you real quick. I was going to do this as a separate video. I might as well do it with this one as well. I was going to speak to it in a separate video, but let me make this a little larger for you. I've been following this case a little bit. I'll get the court opinion in a moment, you know, and then I'll do a separate video of that. But I just want to speak to this real quick. Court ruling on e-cigarettes could set a dangerous precedent. July 21st, 2017. This comes from the Competitive Enterprise Institute, which was one of the plaintiffs, as well as CASA, went against the Department of Transportation in regards to the airlines. So it says, today, the United States Court of Appeals for the District of Columbia ruled against a lawsuit brought by the Competitive Enterprise Institute, the consumer of the CASA, and former CEI employee Gordon Cummings, challenging a U.S. Department of Transportation regulation banning use of e-cigarettes on planes. By a 2-to-1 majority, the appeals court said that DOT could ban e-cigarette use on planes under Congress's 1987 no smoking law for airlines. Give me 5 minutes, thank you. In a lengthy dissent, Judge Douglas H. Ginsburg stated that this was an unjustified distortion of the statute's meaning. Airlines already banned vaping on planes, but DOT nevertheless imposed its own regulatory ban as well, essentially freezing those airline policies in place. CEI is considering whether to appeal the ruling. The lawsuit, initially filed in April 2016, alleged that DOT has no authority to issue such a ban, and that the agency is illegally rewriting congressional law. No, they were just interpreting it. And not only that, it's common sense. You're in an enclosed environment, vaping on a plane. That's so stupid. Don't CASA has something else to do with money, with all those donations that they get. It's ridiculous. Anyway, so, you know, CASA lost that way. You know, the entire industry and / community lost another way with the Judge Amy Berman Jackson's decision. We didn't do very well today, I can tell you that. But, oh well. We can still vape illegally until August 8, 2018, unless, you know, or really up to November 8, 2018, unless the FDA decides to revert that back to August 8, 2018. And maybe Congress will do something for us, though I doubt that very much. And that's that. So enjoy your vapor products while you have them. And after August 8, 2018 / November 8th, 2018, any products that don't have a FDA marketing order will become illegal. And that's when the ATF and all these other characters kick into place, because they were considered as illicit trade, illicit products. They were treated as no different than a combusted cigarette trafficking enterprise. And then people start to go to jail over that, have confiscation of all their products, and it's going to get pretty nasty after, especially after November 8, 2018. So up until that time, enjoy your vaping. Keep calm, vape on if you can. And then when a big black market is created, then the ATF, Homeland Security, Customs Border Protection Services will go after that, clean it all up after about 5-10 years. And, well, might have to go back to premium cigars. I don't know. And that premium cigar case is pending now in court, along with that might lose as well. I don't know. We'll see what happens. So all I have left is combusted cigarettes, I guess. Smokeless tobacco. Might have to get the nicotine patch, but no, I've heard bad things about that. I don't know about all that crap. Anyway, sorry to import all this negative / bad, sad news, but I've always said reality is harsh. There's a harsh reality we have, and now it's even harsher. Possibly Congress could turn this around for our benefit, but do not rely on them. At least I don't rely on Congress. Possibly HR 2194 hunter legislation may come out, in 2018. Actually, that might be the best that we have. I don't want that. I don't like the language in that bill, but it's a lot better than having every single vaping product banned without an FDA marketing order. Anyway, on that point, you guys have a good one, and bye.